Hey guys, welcome back to my channel, True Crime Matters, where we talk about and analyze everything true crime. I'm Tara Marie, and it is so nice to have you back. Thank you so much for joining me today. If you are new here, welcome. So let's get right to it. We have some major updates on the Menendez brothers case. If you caught last week's press conference, you know exactly what I'm talking about. And if you didn't, oh boy, buckle up because we've got a lot to unpack here. Last week, newly elected Los Angeles County District Attorney Nathan Hochman held a press conference that left many people absolutely outraged. He announced that his office was officially opposing the habeas petition filed by Erik and Lyle Menendez nearly 2 years ago. Now, if you need a quick refresher on the case, I did a deep dive, which I'll link down below. But to do a quick recap, the Menendez brothers, Lyle and Erik, are serving life sentences for the murder of their parents, Jose and Kitty Menendez, back in 1989. The prosecution painted a picture of two greedy sons trying to cash in on their parents' fortune, but the defense argued it was self-defense after years of severe abuse. The brothers claimed they had threatened to expose their wealthy, top-level executive father as a child molester just days before the murders, and they were terrified he would kill them first. The first trial? Deadlock juries. Interestingly, it was divided by male versus female jurors. The women believed the boys had been horrifically abused, while the men believed either they had killed for money, or even if they were being abused, they had means to escape, and it was not in self-defense. The second trial was different. The judge excluded critical abuse evidence and even removed manslaughter off the table, which ultimately led to their conviction for first-degree murder without parole. Fast forward to 2023, when their attorneys filed a habeas corpus petition citing new evidence. One piece of evidence? A 1988 letter from Erik to his cousin Andy revealing ongoing sexual abuse by his father. The other, a bombshell allegation from former RCA boy band member Roy Rosselló, who publicly accused Jose Menendez of drugging and raping him when he was just 14 years old. Back then, Jose was an RCA executive and managed the boy band. Now, in late 2024, just last year, when former Los Angeles DA George Gascón was still in office, things were looking hopeful for the Menendez brothers, probably the most hopeful they had been in 35 years. And that's because in October of 2024, the case resurfaced in the news when Gascón held a press conference revealing that his office had been inundated with phone calls following the release of the Netflix series Monster, the Lyle and Erik Menendez story. The flood of calls and emails urged the release of the brothers, prompting Gascón to publicly address the matter. He emphasized that his office was actively reviewing all of the evidence and reiterated his strong belief in the rehabilitation of criminals. Later in October, in a separate press conference, after meeting both sides of the Menendez family who support the brothers' release, Gascón made the bold statement that he did not believe the brothers deserved to spend the rest of their lives in prison.
Do you think the Menendez brothers will walk free someday?
Given the totality of the circumstances, I don't think that they deserve to be in prison until they die, okay? I don't believe that.
He went even further, announcing his intention to recommend resentencing to the judge and officially scheduled a resentencing hearing for late November.
Let me begin by telling you that this is a case where we've had many people in this office spend a great deal of time reviewing the case. I have to tell you unequivocally that we don't have a universal agreement. There are people in the office that strongly believe that the Menendez brothers should stay in prison the rest of their life, and they do not believe that they were molested. And there are people in the office that strongly believe that they should be released immediately and that they were in fact molested. I have to tell you that after a very careful review of all the arguments that were made for people on both sides of this equation. I came to a place where I believe that under the law, resentencing is appropriate, and I am going to recommend that to a court tomorrow.
But then election night happened, and Gascón lost the election by a landslide to Nathan Hochman, a former federal prosecutor. And just like that, everything changed overnight for the Menendez brothers. So that brings us to the most recent development in the Menendez brothers' fight for freedom. Last week, the new DA Hochman held a press conference announcing that he was recommending the court deny the brothers' habeas petition.
Tonight, a major setback to the Menendez brothers in one of their bids for freedom.
What we found out is that Erik and Lyle Menendez had told 5 different versions of the events of what had happened.
DA Nathan Hochman, who took office in December, says the court should deny a habeas petition filed by Erik and Lyle, one of the 3 paths the brothers are taking to try to get out of prison for the 1989 shotgun murders of their parents, Jose and Kitty, in their Beverly Hills mansion.
Now, for me, watching Hochman was like seeing the polar opposite of former DA George Gascón. What did you think? For those who may not know, a habeas petition is a formal challenge to the legality of a conviction, often considered the last resort once appeals have been exhausted. If new evidence meets the legal standard, it could eventually lead to a convict's release. And remember, in the habeas petition the brothers filed in 2023, they presented 2 key pieces of new evidence. However, according to Hochman, neither of them met the legal requirements for a new trial. He broke it down by explaining that for a successful habeas petition, new evidence must be new, be timely, and not discoverable at the time of the trial, show no unreasonable delay in filing once it was found, be credible, and be admissible in court. So what's Hochman's argument? Well, first he claimed that the letter, which was a major part of the brothers' petition, was not credible evidence.
So now we have a letter filed in May of 2023 that is supposedly a 1988 letter written from Erik Menendez to Andy Cano about this sexual abuse. Never discussed in any of the 2 trials when Erik Menendez testified or Andy Cano testified. And we believe it's inconceivable, as we've argued in our papers, and defies common sense, that if they had evidence that would show that that sexual abuse had been communicated not just 6 years before the events, but 9 months before the 1989 killings, that it would absolutely have come out during one or both of their testimonies. So the fact that it didn't come out, again, goes to whether or not this evidence, first, was discovered after the trial. If Erik Menendez wrote this letter, he had it, or knew about it, or Andy Cano had it, and certainly knew about it, by the time of the 1993 trials. In fact, it's a 1988 letter. They would certainly have it by the time of the 1995 trials. So to say that this letter was not discovered after the trial, as it's been alleged in the defense papers, we believe is just wrong. The second thing with this letter is that if the letter was real, then the question is, when is the substantial delay triggered in actually filing this motion? So what you find in the motion is Erik Menendez is saying, I didn't know about the letter until effectively a 2015 special by Barbara Walters, where this letter had been given to her, and she actually broadcast this letter in 2015. But remember, this motion, this habeas motion, this second habeas motion, was not brought in 2015. It wasn't brought in 2020. It was brought in 2023. So one of the additional standards for a habeas motion is that you do not engage in substantial delay in bringing this motion. Andy Cano had long since passed. He passed in 2003. So he was not around to actually cross-examine and see if this letter was an actual letter that he had received or not. Or perhaps he received it, but he didn't receive it in 1988. He received it at some date much later than that. So this particular letter it could have been discovered prior or during the trials, and then wasn't presented. It was presented after substantial delay, even when both Lyle and Erik Menendez say that they had this letter. The last standard, of course, is credibility. Is this credible evidence? We argue in many different ways it is not credible evidence. The first way, as I've discussed before, is that if they had this evidence, if this letter truly existed, the defense counsel would have absolutely used it at the trial, because it would have helped corroborate both Erik Menendez's testimony about sexual abuse and Andy Cano's testimony about sexual abuse, because that letter was 8 months, roughly 8 or 9 months before the murders, not 6 years before the murders. But it was never mentioned, its contents were never mentioned, it was never produced or in any way used during either one of the two trials. But the notion that this letter could be part of a continuum of lies and deceit and fabricating stories required us to go back into the history of the Menendez case to analyze whether or not that would be true. So we looked at, again, the credibility of the letters, and particularly this Andy Cano 1988 supposed letter, weighed it in the continuum of lies, and it calls into drastic question whether or not this is in fact a 1988 letter written by Erik Menendez to Andy Cano about this sexual abuse. But again, even if it is, it's not timely because it was not presented at the time of trial. They substantially delayed in bringing this motion from at least 2015 to 2023, and in certain respects, it's also not admissible. Which is why we conclude in our informal response that the court should deny the current habeas petition by the Menendez brothers. And if the court decides not to deny it at this point, the next motion or move for the court is to order what's called an order to show cause. Then we will file this again, this response, in response to the order to show cause. The Menendezes can reply, and the court can rule at that point or have a hearing in the habeas matter.
Now, let's talk about what he said of the second piece of new evidence, the testimony of Roy Rosselló.
Let me deal with the Roy Rosselló letter to give you an idea how the admissibility standard works. The letter has to comply with the admissibility standards of evidence in a court. Now remember, in 1989, August 20th, the issue is what is going on in Erik and Lyle's head at the time they shotgunned their parents 12 times to their death. Are they again have an actual fear of imminent harm and death, that their parents were going to kill them that night? Or was it a willful, premeditated, and deliberate act on their part? What they have said about the Roy Rosselló allegations, that he was sexually abused by Jose Menendez in the early 1980s, is that they didn't know about this in 1989. They didn't know about this in 1999 or 2009. They first found out about this in 2022, or approximately 2022, about over 30 years later after the killings. So the evidence, if in fact this is true of what Roy Rosselló is saying, would not be admissible to show their state of mind in 1989 because they didn't know about it in 1989. So again, it would fail the admissibility standard, as we've argued in our habeas informal response.
Which, I'll tell you my own opinion on the statement a little bit later, but let me know what you all think about what he had just said there. Do you agree with Hochman's reasoning, or do you think the new evidence should be enough for a new trial? Let me know what you think in the comments. Now, Hochman also claimed his office hasn't even seen the original letter. But just yesterday, I heard Erik's lawyer, Mark Garrigo, say the original letter was handed over to the DA 2 years ago. So what is the truth, and where is the original copy of that letter? With all of that said, later in the press conference, Hochman reminded everyone that the Menendez brothers are pursuing 3 different avenues in their fight for freedom. The habeas petition, which Hochman has now recommended that the court deny, but ultimately a judge has final say in that. 2, resentencing. And 3 is a clemency request to California Governor Gavin Newsom. Now, Newsom has already said that he's waiting for Hochman's full review before making a decision. But many people believe that Hochman's recent rebuttal of the habeas petition suggests he may not see resentencing as a reasonable option either. He did say, though, that the public will hear his thoughts on the next steps in the coming weeks. Meanwhile, Hochman also revealed that he and his office are still reviewing all of the documents, including prison records, trial transcripts, and court filings, before deciding whether they'll support resentencing. And speaking of resentencing, that hearing is set for March 20th and 21st. Literally exactly a month away. And guys, I'm working on actually setting up my first ever live coverage event for those hearings. Please bear with me. I'm trying to get all the little tech things in place. We'll see if I can make it in time. But I think it would be so cool to cover this hearing live and actually get more interactive with all of you. Let me know what you think. Would you be here for that? And be open for a live discussion during that hearing. Anyway, following that press conference last week, the families of Erik and Lyle Menendez released their own statement on February 21st, 2025, which read, quote, District Attorney Nathan Hochman took us right back to 1996 today. He opened the wounds that we have spent decades trying to heal. He didn't listen to us. We are profoundly disappointed by his remarks, in which he effectively tore up new evidence and discredited the trauma they experienced. To suggest that the years of abuse couldn't have led to the tragedy in 1989 is not only outrageous, but also dangerous. Abuse does not exist in a vacuum. It leaves lasting scars, rewires the brain, and traps victims in cycles of fear and trauma. To say it played no role in Erik and Lyle's actions is to ignore decades of psychological research and basic human understanding. For DA Hochman to claim that new evidence should have been submitted at trial is absurd. The justice system failed Erik and Lyle then, and it continues to fail them now. The fact remains, the jury in their second trial never heard the full truth. Key testimony was kept from them, and now DA Hochman is attempting to erase this reality once again. He is not just dismissing Erik and Lyle's experiences, he is silencing survivors everywhere who know what it's like to be disbelieved, ignored, and re-traumatized by a system designed to protect them. DA Hochman promised to take politics out of prosecutorial decisions, but his actions today say otherwise. If he is truly committed to justice, he will follow the law and issue a resentencing recommendation that reflects Erik and Lyle's overwhelming rehabilitation and the undeniable standards set by AB 600. And he will stop trying to bury the truth about their abuse. For over 3 decades, our family has lived with the weight of what Erik and Lyle endured. Abuse that shaped their lives, fear that defined their childhood, and a justice system that refused to see them as victims. We have fought tirelessly for the truth to be recognized. Our hope now rests with Judge Jesek, and he will examine the evidence in their case without prejudice, carefully adhering to California law with modern understanding of trauma. Our family has been waiting 35 years for the justice system to acknowledge what we have always known. We are so incredibly proud of the men Erik and Lyle have become, men who have dedicated their lives to helping others, despite believing they would never have a second chance. We will continue to advocate for their release so that we could heal and finally move forward. All we are asking for is to right this decades-long injustice. And then they left more information about their website, which is justiceforerikandlyle.org. So all of that said, Now we are just really waiting for the upcoming resentencing hearing scheduled for March 20th and 21st. Now, what do I think about all of this? Well, first of all, for me, it's been fascinating as somebody who studied media, really, to watch two different DAs not just take completely opposite stances on a particular case, but it was also interesting to watch how they tried to utilize the media when their office has been really inundated with citizens demanding the release of the brothers. Gascón held press conferences in response to the public pressure after the Netflix series, but Hochman, he took it even further. Not only did he have a press conference of his own, but his office actually produced and released their own video about the case, which I did take the time to watch. And honestly, watching it felt odd. It was sort of like watching a true crime YouTube video, but made by the prosecutor himself. In it, he laid out the legal timeline of the case. He explained how the DA's office operates, and it definitely felt like a direct response to all the people out there supporting the brothers.
The anatomy of the Menendez case starts with the horrific murders that occurred at around 10 p.m. on August 20th, 1989, in the Menendez's Beverly Hills home. Jose Menendez and his wife, Kitty Menendez, while they sat in their den watching TV, were violently shotgunned to death by their own sons. The murderers shot them over 12 times, including a shotgun blast to the back of Jose's head, blast to his kneecaps after he was dead, and a point-blank blast to Kitty's face while she lay on the floor moaning in agony. Officers described the crime scene as one of the most horrific murder scenes they had ever encountered.
Now, the press conference. It bothered me. I'll be honest, I actually had a really hard time listening to Hochman's press conference. And I don't know, maybe I was just hangry or something, because normally I really love hearing both sides of an argument equally. But this time, something really got under my skin about it. And I had to really sit with myself for a bit and think about why it was bothering me so much. And then I realized it really came down to, it's the issue of abuse. Let's not forget the first trial ended in a hung jury because the abuse allegations. That's how much it mattered. So I couldn't stop thinking about how Hochman's statements were landing with actual abuse survivors listening to him dismiss this additional abuse evidence. Now, about Hochman's statement regarding the letter not being admissible and why, one thing that really bugged me is when he said, quote, "If the letter truly existed, the defense would have used it at trial, and yet it was never mentioned." Like, seriously? Obviously, they would have used it if they had known about it. Not to mention, that's literally one of the requirements for the habeas, that the evidence must be new and not used at trial or not known about at trial. Well, it was newly discovered, so I'm not sure I agree with his assessment here. So, and when he says it was never mentioned in trial, technically it did come out in the first trial that Erik was communicating with this cousin about the abuse when he was a teenager. So in a way, it was hinted at during trial, but the evidence wasn't actually known about or presented. I would think if both Andy and Erik had remembered it existed, they would have brought it forth. So they really are calling into question the credibility of the letter here. The other question I have is, where is the original letter? Why is the DA saying he doesn't have it or never saw it? Here's the statement made by Mark Garagos, saying they absolutely handed over the original letter over 2 years ago.
And the letter was really infuriating because the letter was found more than 10 years after Andy Cano had died. It was in his effects, and it was found by a journalist in the house, mind you, of Jose's sister. And Jose's sister then talked to Kitty's sister, Joan, and said, "Look what I found." And Joan realized the significance and had Marta, Jose's sister, in blue pen initial the back of it. And guess what? I gave that copy with the blue pen initial and a declaration to the DA. They acknowledge that it was an original a year ago. Today they don't. They don't acknowledge also that Joan Vandermolen testified about this 14 months ago under oath and said, I recognized how important this was when we found it. And mind you, Lyle and Erik had been in custody for over 20 years. They had no hope at that point. They weren't trying to do an appeal. All of this was really kabuki theater today. The habeas that was filed today that I got 1 minute before the press conference is the almost virtually identical habeas that was going to be filed by the same group of disgruntled internal prosecutors that were back then in the DA's office or have survived since.
So where is this original letter, and why is the DA saying he doesn't have it? Then Hochman also said Erik only realized the letter existed after it was mentioned on a Barbara Walters special in 2015. And because the brothers didn't immediately file the habeas then, after that, the evidence is considered not timely. Now, technically, I agree with him here. They didn't file it right away, so it's not timely. But as soon as Roy Rosselló came forward with his allegations, they realized that together, the testimony with Rosselló and the letter, it would make a stronger case for a habeas. Neither was used in the original trial or any appeal, so it's completely fair to argue that it could have influenced the verdict. Now, about Hochman's take on why Roy Rosselló's testimony isn't admissible. Just wow. Now, here's the part where I was actually flabbergasted. Hochman admitted that Rosselló's allegations met the timely standard, but then he dismissed them by saying, quote, since this is new evidence, it could not have affected their state of mind prior to the crime. Like, what? How is that the only way Rosselló's information could have changed the outcome of the jury's decision? To me, he's completely ignoring the fact that if the jury had heard Rosselló's testimony, it could have changed the outcome of the trial. Remember, most of the jurors who voted guilty in both trials said they did so because they didn't believe the brothers were telling the truth about the abuse. So, I don't know, wouldn't hearing another survivor of their father's abuse have potentially changed the outcome of the trial? And then Hochman said something that actually made me grind my teeth. Quote, sexual abuse in this situation may have been a motivation for Erik and Lyle to do what they did, but it does not constitute self-defense. And that right there shows me that he is completely ignoring the key to the defense's argument. And I think a lot of people miss this point too. The key to understanding the defense's argument is understanding that the brothers did not say they killed their parents just because they were being abused. They said they killed their parents because Lyle had threatened to expose their father as a child molester if he didn't stop abusing Erik. And the statement from Jose after that threat was to the effect of, well, you've made your decision, now I have to make mine, which the boys took to mean, well, it seems like you're on a track to exposing me anyway, so now I'll have to make a decision if I'll roll over and let you ruin my life, or I'll take your life so you can't destroy me. Let's not forget also that Jose Menendez was an extremely powerful and rich man, and he was also armed. I think most people either forget or never knew that their mother Kitty recently had bought a gun. So in the back of their heads, they could have really believed their parents would have used the weapon against them to protect their own lives. And in response to this idea, some people say, well, I was abused and I didn't kill my parents. I just left the home. But not only are those people missing the whole key that I just said, that the brothers felt that they had threatened to expose their father as a child molester, and so it was either kill or be killed. The other piece to that is, even if they did try to run away, Jose Menendez wasn't just some random abusive father. He had connections. He had power, money. He could reach them anywhere in the world if they had tried to escape. And Erik even thought that his mother had magical powers because she seemed to know everything they did before they did anything. Well, it turns out after their deaths, it was discovered that she had been recording all of the phone conversations. Just let that sink in. She was recording phone conversations. Why would she be monitoring him like that? Well, maybe it was because they wanted to make sure their darkest secret was never getting out. Even Erik's therapist had a deal with Jose to tell him everything that Erik was saying in those sessions, which not only is terrifyingly controlling, it's also completely unethical. Also in the press conference, Hochman made a point of how the boys didn't immediately come out with the story of their parents' abuse, which he said pointed to how it could be fabricated. Meanwhile, multiple experts who have studied this case over the years have said that the way Erik and Lyle kept quiet about the abuse, even after their arrests, and even went so far as to they kept talking very highly of their father, that's very consistent with how most SA survivors process their trauma in secret because of all of the shame tied to it. I mean, just think about how long it took Roy Rosselló to come out about his own, personal experience with Jose. Hochman also went on to say that the evidence of the abuse was extremely lacking in the case. Well, I guess he either forgot or ignored the medical evidence. For those who don't know, when Erik was 7 years old, he was taken to Princeton University Hospital, the ER actually, with an unexplained injury to the back of his throat. A doctor testified that in the first trial, the injury was consistent with oral rape in children. In fact, it is so consistent that today, dentists are trained to recognize that exact injury in children so they can report it to police. But sadly, in this case, at that time, it wasn't well known, so no one reported that injury on Erik to police. I guess Hochman also forgot about how Kitty Menendez told her therapist just weeks before the murders that her family had, quote, sick and embarrassing secrets. Not to mention, he ignored the testimony of multiple cousins and relatives who testified to the horrific abuse they either witnessed firsthand or overheard while they were in the home. And as for Roy Rosselló, I can't help but feel so sad for Rosselló here. I don't believe this man is lying. It has taken him so many years to process his trauma and to finally have the courage to speak out. And now, Hochman just shrugged off his statement like it wouldn't have mattered to a jury. I find that to be the most devastating statement made in that press conference. Like, he was completely invalidating him. I can only imagine how that made other abuse survivors feel hearing that and watching, this press conference. All of that said, I guess now we all just wait to see what happens next. But what do you all think? Do you agree with Hochman? Do you think he was right to deny the habeas? Do you think he'll change his stance at the resentencing hearing? And after 35 years in prison, do you think that the brothers deserve a second chance? Let me know what you all think in the comments. If you have found this video helpful or interesting, please take a second to subscribe so we don't lose each other. It costs nothing and it would mean so much to me to have your support. And as always, thank you so much for watching. Be careful out there.